Michael Foreman, who will be our second witness, is the Deputy Director of Legal Programs and Director of the Employment Discrimination Project for the Lawyers Committee for Civil Rights under the law. He is also the Lawyers Committee representative on the Leadership Conference's Civil Rights Employment Discrimination Task Force. Before joining the Lawyers Committee, Mr. Foreman was acting Deputy General Counsel for the United States Commission on Civil Rights. He earned his bachelor's degree from Shippensburg State College in Pennsylvania and his J.D. from the Duquesne University School of Law. Welcome, Mr. Foreman.
Chairman Andrews, Ranking Member Klein, members of the committee, thank you for taking up this important issue. My name, again, is Michael Foreman. I am here testifying on behalf of the Leadership Conference on Civil Rights, which is a coalition of over 200 national organizations that's dedicated to providing equal opportunity to all members of our society. Given the fact that this committee is taking up this issue, it is obvious that you understand the importance of this issue. But I don't want to put too small a point on that. In 1979, about 1% of employers in this country had binding pre-dispute, and I do want to focus on pre-dispute binding arbitration clauses for employment. In 2007, that figure had moved to 25%. If that trend continues, which my colleague here indicated it will, in the very foreseeable future, we are going to see a legal system where civil rights employment disputes are not going to be decided by judges who are publicly appointed or by juries of our peers, which is a bedrock of our society. But they're going to be decided by a small group of arbitrators, largely paid by employers, in confidential settlements with no public accountability. The current issue before this committee, and I want to stress this, is not whether there should be binding arbitration in employment disputes. We support binding arbitration of employment disputes when it is voluntary, when it is knowing, and when there is, in fact, a dispute to be arbitrated. What we do not support is pre-dispute binding arbitration that are hidden in applications, that are hidden in employee handbooks, or are forced on employees. And that's the reason we support the provision in H.R. 5129. The sad reality for many of the millions of clients that our organizations represent is there really is no choice. There is no choice in what they can do. In making good social policy, we can't divorce ourselves from reality. Do any of us really believe that most blue-collar workers, if they walk in and refuse to sign the application because it has a binding arbitration clause, that they'll get that job? Or in Ms. Jones's case, do any of us really believe if she had told Halliburton, I'm sorry, I can't sign that agreement, that she would have gotten the job? Our workers' choices are between putting food on the table or possibly getting health insurance, or possibly being able to pay their mortgage. That is not a real choice, and that's all this bill is attempting to do in this provision. Provision is to provide that choice. In practice, mandatory arbitration agreements are not supposed to change substantive rights. They're only supposed to change the forum in which they're doing it. But that is also, sadly, not true. In the detailed statement, we've addressed that. It is not insignificant to take away the right to be heard in court or the right to be heard by a jury. In some of the statistics we provided that are provided by the American Arbitration Association, arbitrations dealing with Pfizer for a specific time period, the decision rate was 97% win rate for the employer. For Halliburton, it was an 82%. They prefer arbitration because they win in arbitration most of the time. It is one thing to permit employees to willingly give that up. It is another thing to take that choice away before there's even a dispute to be taken away. I don't need to spend a lot of time talking about this in the abstract. You just heard testimony from Ms. Jones about some of the ugliness, probably one of the most ugliest employment situations that you can imagine. But let's think about the consequences that when she returns from helping serve our country, and that ugliness is revisited by the fact that she cannot even have the rights that this Congress has provided to her exercised in a court of law or before a jury. What type of ugliness is that? And that is something that we want to correct. The Supreme Court has virtually invited Congress repeatedly through the Waffle House, through the Gilmer decision and others, to specifically tell them, if you don't want these subject to pre-dispute arbitration, then tell us so. In fact, what we're asking you to do is accept that invitation. We're not asking you to ban binding arbitration across the board, but what we are asking you to do is ban it in a pre-dispute and then only if it's willing. And I'll be available to answer questions and provide any other information. Thank you.